Good evening. We've had major news from the Supreme Court today with its decision in Peggy Young versus United Parcel Service. This case has garnered heightened attention from women's rights groups due to its impact on the employment rights of pregnant women. In a 6-3 vote, the Supreme Court vacated and remanded the previous district court's decision, sending the case back to the lower court for another trial based on some key considerations. What exactly does the remand mean, and what are these key considerations? Stay tuned. Welcome back. To help us understand the legal implications of this case, legal expert Eric Dogan joins us in this studio. Hello, Eric. Thank you for joining us tonight.
Thank you, Ruti. It's good to be here.
So, Eric, can you please tell us what happened? Why did Peggy Young sue UPS?
Sure, Ruti. Peggy Young was a delivery truck driver working for UPS in Landover, Maryland, and when she became pregnant in 2006, her doctor told her she needed to stop lifting anything weighing more than 20 pounds. When she went to UPS with her lifting restriction, she was told that she could not work until that lifting restriction was lifted.
Okay, it's my understanding that Miss Young was actually told to go home until she was no longer pregnant. Is that right?
That's right, Ruting. Miss Young asked for a transfer to light duty, which could mean working in an office or driving her out with a colleague to help with the lifting, but UPS denied her request on the basis that lifting more than 20 pounds was an essential function of her job, which meant she was placed on leave without pay and subsequently lost her employee medical coverage.
So Miss Young is pregnant and suddenly finds herself not just without medical coverage, but also without any source of income to pay for any of her pregnancy-related medical bills.
Unfortunately, yes. So Miss Young filed a lawsuit based on disparate treatment against UPS, claiming that UPS discriminated against her by refusing to accommodate her pregnancy-related medical condition.
I see. Now tell me, are companies generally required to make accommodations for employees who find themselves unable to work for whatever reason?
Well, that's a good question, Ruting. UPS policy at the time was to offer light duty as an accommodation to employees who fell into one of three categories: either drivers who were injured on the job, drivers who lost their Department of Transportation certifications, or drivers who suffered from disability under the Americans with Disabilities Act.
So employees who did not fall into any of these categories, whether male or female, are not eligible for light duty assignments.
That's right.
And even though the company had a policy of accommodating other non-pregnant drivers, they weren't willing to offer those accommodations to Miss Young.
Exactly. UPS argued that its decision to deny accommodation to Young was non-discriminatory because it followed a company policy that doesn't take pregnancy into account, a so-called pregnancy blind policy.
So how did this argument play out in court?
Well, the District Court and the Fourth Circuit Court of Appeals agreed with UPS that discrimination hadn't occurred, so Young appealed to the U.S. Supreme Court, asking it to review the lower court's decision.
So, Eric, what exactly was the question the Supreme Court faced?
Well, Ruting, the essential question is whether employers are required to provide the same work accommodations to an employee with pregnancy-related work limitations as it provides to employees with similar but non-pregnancy-related work limitations.
You mean the three types of people who receive the light duty under UPS policy?
That's right. But the matter behind this question is interpretation of the intent and details of the laws. The second clause of the Pregnancy Discrimination Act, the PDA, says that women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. So, believe it or not, the argument came down to the interpretation of the words similar in their ability or inability to work. Young claimed that her inability to work was similar to those who were injured on the job and couldn't do any heavy lifting.
You mean someone who, let's say, pulled his back while lifting a package on the job?
Exactly. She argued that a person who injures his back on the job and receives temporary light duty is no different than her, so she shouldn't be treated differently.
What was UPS argument against this?
UPS claimed it was treating Young the same as it would have treated a worker who pulled his back out while lifting groceries or exercising. Both could be denied light duty because they were injured off the job.
So does today's decision mean the Supreme Court sided with Young that there was discrimination when her pregnancy was not accommodated?
Well, not exactly. The Supreme Court actually ended up rejecting both Young's and UPS's arguments about interpretation of the PDA. What is central to the case is the court's decision to apply a legal framework called McDonnell-Douglas burden shifting, which has historically been used to determine evidence of employment discrimination. This sets precedent that the framework is applicable to pregnancy-related discrimination cases.
So the president provided a roadmap, if you will, for disabled employees to prove employment discrimination, and today the Supreme Court said that pregnant women are allowed to take this road, right?
Yeah, you could say that. It's important to remember that the issue the Supreme Court is deciding isn't the issue of discrimination. The lower courts had issued summary judgment in favor of UPS, meaning that the previous judges had decided their ruling was sufficient and the case didn't warrant a trial by jury. And this is really the crux of the issue here. The Supreme Court is deciding whether that decision to grant summary judgment instead of a trial was the correct interpretation of the law.
So the victory is that the Supreme Court determined Peggy Young's case should be heard in a trial in the previous court.
Right. And the justices' opinions provide a lot of guidance for Young as far as how to make her case a trial. Not only do they determine the acceptability of her application of the McDonnell-Douglas framework in presenting her case, some of the justices even go as far as suggesting arguments in support of proving UPS's discrimination.
So let's take a look at the opinions.
First, let's take a look at Justice Breyer's majority opinion, which included Justices Roberts, Ginsburg, Sotomayor, and Kagan. The majority decision was based on an interpretation of the second clause of the Pregnancy Discrimination Act, which discusses how employers must treat women affected by pregnancy the same for all employment-related purposes as others not so affected but similar in their ability or inability to work. The decision describes how intentional discrimination may be inferred by applying the McDonnell-Douglas framework. To do this, the plaintiff must provide evidence that significant burden was imposed by UPS's policies, pointing to the numbers of non-pregnant versus pregnant workers accommodated. The court notes that the Fourth Circuit's decision did not consider the combined effects of UPS's policies of accommodating other classes of workers who requested temporary light duty, asking why, when the employer accommodated so many, could it not accommodate pregnant women as well? Justice Samuel Alito wrote a concurring opinion, which refers to the second clause of the Pregnancy Discrimination Act, characterizing it as critical and not superfluous. He believes it add a further requirement of equal treatment irrespective of intent. He goes on to discuss what situations are comparable to Young's in terms of policy, pointing out that she's equal to a worker who requires light duty due to a loss of DOT license, because this restriction may also have off-the-job causes.
Great summary of the majority and consenting opinions, Ruting. In dissent, Justice Antonin Scalia argued that the primary intent of the PDA was to clarify that pregnancy discrimination falls under Title VII's definition of sex discrimination. His dissent criticizes the majority opinion as splendidly unconnected with the text and even the legislative history of the Pregnancy Discrimination Act, and that the majority is basically crafting a new law, calling it inventiveness posing as scholarship. Justice Anthony Kennedy wrote a separate, less colorful dissent, stating that the majority interpreted the act in a way that conflates disparate impact with disparate treatment and would result in confusion in litigating pregnancy discrimination cases.
Even so, the Supreme Court remanded the case to the Fourth Circuit Court to ultimately decide the validity of Peggy Young's pregnancy discrimination claims. This Supreme Court case makes it significantly more likely that all pregnant women denied workplace accommodations will succeed in their legal claims against the employers who denied them. In the intervening years between Young's first filing and this court decision, not only did the UPS change its light-duty policy to include pregnant workers, but federal regulations also changed, with a 2008 amendment to the ADA and a 2014 EEOC guideline, which explicitly describes how light duty may not be denied to a pregnancy-related disability.
So interesting to hear and details of the court's decision. I think we can all agree it's certainly a victory for women. Thank you, Eric, for discussing the case with us.
My pleasure, Ruting.
Thank you for joining us. Good night. Good night.